morning, everyone. Today is November 5th, 2020, and as we await final election results, we're here for Mediation, the New Possibilities Hour. This is part of the Will Work for Food project, which was created last spring by Natalie Armstrong-Lotan, and I'm so happy that she invited me to be part of the team and work with her on these great presentations. There's no charge for these great webinars. Rather, we ask you to contribute to a food bank if you like what you see. And the ADR and litigation communities have been so generous in responding and supporting food banks. It's one of my favorite parts of the hour every week, Natalie, to ask you to update us, please, on just how generous our communities have been.
So Jeff, you know, this is also my favorite part of the program, and I'm happy to announce that yesterday morning we topped $58,000 in donations to World Food Banks. So $58,000, it's such a lovely, lovely number for our industry to have contributed. Way to go, everybody. Let's keep the money coming in for our neighbors and friends who have some insecurity with their food, and we'll keep supporting the food banks. But thanks very much.
Yeah. Yes, and thank you all for your generosity in helping those with food insecurity at these times. Well, we have a great program today. It's going to be moderated by our friend Arnie Levinson up in the San Francisco Bay Area. Our topic is mediating and settling COVID-19 related disability claims. Arnie has had a very distinguished career, first as a litigator in the San Francisco Bay Area, and now he's joined the Brotherhood of Mediators, and we're very happy to have him as a mediator. Arnie is affiliated with ADR Services in the San Francisco Bay Area, and he and I share a passion for mediating insurance coverage cases of every shape and size. It's an acquired taste, and both Arnie and I have acquired it. And we have an outstanding panel that Arnie has put together. Arnie, thank you so much for your hard work. Let me turn it over to you to mention the food banks that you and your panelists would encourage us to support and to give us a wonderful presentation. Arnie, the floor is yours.
Thank you, Jeff. My food bank is the San Francisco Marin Food Bank up here, and Glenn and Misty, maybe you could mention your favorites.
Mine is the Los Angeles Food Bank.
And mine is the Valley Food Bank.
Okay. So I'm sure nobody knows any of these panelists. It's not as if they're not superstars in the field, which they of course are. Glenn Cantor, everybody knows that Glenn's a founding partner of Cantor & Cantor. He's been representing insurers for 35 years in their efforts to obtain health, life, and disability insurance. And Misty Murray is a partner at Inshaw & Culberson, who's been doing everything to frustrate Glenn's efforts over the last 20 years. She's been defending ERISA plan insurers for 2 decades, both in life, health, and disability insurers, including and breach of fiduciary duty and faith claims. So I'm kind of the potted plant in the middle. Just going to ask a few questions of the panelists, and we're going to try and get both sides of the issues. First thing we're going to do is go through some claims processing issues, and then we'll get kind of into the meat of the claims themselves. So the first issue that we want to talk about is how this is going to affect in-person exams, obtaining records, just putting the claim together for both the insured and the insurer. Glenn, do you want to mention something about that?
Well, sure. As a plaintiff's lawyer, one of our biggest tasks and responsibilities is to assist our clients in getting the evidence they need to support their disability claims. That could be an independent medical exam. Often it's getting the records from their doctor's office. It might be having a functional capacity exam. But when the COVID shutdown hit in March, we were stymied. Doctors' offices weren't open. There were no IMEs being done. And we felt we were in deep trouble because we had a lot of deadlines to deal with and no way to solve our problems. Misty?
Well, handing it over to me, I mean, as far as the, from an insurer or claim administrator's perspective, the burden really is on the insured, and that's probably why this gave so much heartache to Glenn to submit the proof of loss. And that's going to be the case whether you're under an ERISA plan or an individual plan. But at the same time, insurers and claims administrators, once they get the information, they have to evaluate it, and they can request additional records, whether it be from medical providers. They can also request in-person exams. So some of those same issues that the insureds were facing and claimants were facing, insurance companies and administrators were facing as well. Once they get the proof of loss in and they have additional questions or information they need, there was, as everybody knows, a pretty massive shutdown, particularly in California, around March or April. And that is when, and I don't want to do Arnie's job, but that's when the DOL stepped in and issued some relief, at least for the claimant side, in trying to give them additional time to get information and to perfect a claim.
I was just about to ask about that, Misty. Yeah, so I'm assuming that the DOL has helped folks out. And Glenn, maybe you could take us through some of those changes.
Well, not so much changes as the Department of Labor, unlike other parts of the government, recognized what was going on and put in regulations freezing the time requirements, at least under ERISA. As practitioners probably know, the vast majority of non-Social Security and non-workers' compensation disability claims and non-state claims come from employer-provided plans, and they're going to be governed by ERISA. As also is known, if an ERISA claim is denied under current regulations, the claimant has 180 days to submit additional information. Often carriers are flexible. Of course, Misty's carriers are all flexible. We ask them for more time. Others weren't. But the Department of Labor stepped in and said, look, we recognize the problem. Effective March 1st, any time deadline is frozen. And it's frozen until the end of the national emergency. And as far as I know, that national emergency is still in place and could be in place pessimistically for another year. So that 180-day deadline for the submission of claims materials or support of an appeal is technically frozen. If an appeal was due March 3rd, it's still frozen. Unfortunately, let me back up. That helps alleviate the lawyer's stress about deadlines and malpractice, but for the claimants who are without any funds, it's not helping them because they're still under a great deal of financial stress.
So, Misty, are people? What are the carriers doing? Is anybody submitting claims? What's your take on the guideline modifications?
Well, my presumption is yes, people are still submitting claims. I mean, from our perspective, we really haven't seen the fallout or how this is going to play out because these appeal deadlines are now suspended essentially. I have talked to some clients, and back in March, April, when this all played out, I mean, it was just all weird, but I think there are now things are getting back to a little bit more functioning and people are able to get medical records. But, one thing to keep in mind in the ERISA context, and somewhat in the individual context as well, and this applies to the appeals period. So when the initial claim comes in, the carrier does have a certain amount of time, or the administrator has a certain amount of time where they have to issue a decision. And they can and do issue decisions for lack of proof. Now, when you have the ERISA appeals context, that gives the opportunity to the claimant to perfect the claim. So they're able to, go and find additional information, submit additional proof. How that's going to play out in the context of litigation, I think that remains to be seen. But the importance in ERISA is that the court is limited to deciding what's before the administrator in the administrative record. And again, the burden is on the claimant to get the information and submit the proof of loss. Everybody knows most carriers, they're going to reach out and ask for medical records and try and get information as well. But if that record is not perfected, the court is going to be limited to making its decision on based upon whatever is submitted. So I think we're going to have to just wait and see what happens and how those records are presented to the court.
What I'm wondering is, the longer this goes on, do we know if the DOL is going to give a heads up on when they're going to call this extension over? I mean, there are some people that said that we've rounded the corner and this emergency is over. I've heard that I've read it on the news at least. So we know what's an emergency. Is the DOL just going to make a pronouncement that all of a sudden the deadlines are now up? Because then you're going to get an avalanche of claims, aren't you? And does anybody anticipate that the carriers might be given an extension to respond to these?
Well, I saw the same news reports, and from my understanding, the COVID emergency was supposed to end yesterday, but I don't think that happened. I think we could all agree that it's not going to end before January 20th, and who the president is as of January 20th may certainly impact what the DOL does. I think they will give us some kind of advance notice as to how much time we have. I mean, don't forget, if somebody had 4 months left in their appeal period and the freeze is unfrozen, they still have 4 months. So I'm not sure about an avalanche. I will tell you from the experience of my firm, and we are one of the largest, at any one time, we're probably working on 100 appeals to submit, that human nature is human nature. It's like, well, I don't have a deadline, so I have maybe more time. And we're pushing to avoid that because people need their benefits. But I expect there might be an avalanche, but I do not expect the DOL is going to all of a sudden say, well, to the carriers, well, you have more time because the people need their benefits.
It sounds like, Misty, you might get a lot of claims at the same time. Do you think that's possible?
Well, I think we have to remember that this is for the appeal, and it's giving the claimants more time to perfect the record. But once that comes in, then the deadlines for the carriers and claims administrators to make the decisions, that has not changed. So they're supposed to make a decision in 45 days. They can toll the period, they can ask for more time, but that has, as of yet, the time for the administrator to make a decision, the DOL has done nothing with that. I do hope that they're going to issue some more guidance soon, because the way it stands right now, it's just kind of an open-ended deadline, and I don't think that's really good for anybody.
Okay, well, what about the policies that aren't covered by ERISA? You got proof of loss requirements and other internal policy deadlines. What's your take on that, Glenn? Do you want to give us some thoughts?
Actually, I don't know how far and wide this webinar is going. I know at least there's one person from New Jersey watching. We're talking about 50 different states. Here in California, it would thrill me to get a letter in the mail saying, we're sorry, your client didn't submit proof of loss on a timely basis during the COVID emergency, so we're denying the claim. I would have a bad faith lawsuit on file within 24 hours. In fact, I have a case like that pending against a carrier who terminated benefits because an insured with a mental disability couldn't get the records they needed from their psychiatrist whose office was closed. So I think carriers need to be very careful about denying claims during COVID because of the late submission of a claim.
Misty, what do you think? And are you seeing any of that happening?
Not as of yet. I mean, all of these claims right now, I think they're still with the carriers. in the individual context, all individual policies have a proof of loss provision, proof of loss requirement. But as Glenn mentioned, in California, and I think 30 some plus states have a notice prejudice rule, which means you can't deny a claim for timely filing unless you've suffered actual prejudice. Now, actual prejudice, if you can't get the medical records or you can't, get what's needed to process the claim, then that would be actual prejudice. I think what we're going to see more in these, again, the burden is on the insured to submit the proof of loss. Might see denials based upon lack of proof or failure to submit rather than a timeliness issue. I think what happens in the individual context, even though there's not a formal appeal requirement, individual carriers at all times, they always consider additional information. They always give the insured time to submit a claim. At what point, though, is the delay in making the decision going to be considered tantamount to a denial? And I think from the carrier's perspective, if they're delaying a decision because they want to get more information or allow the claimant or insured time to submit, I don't think that's going to be considered unreasonable or bad faith, particularly in the context of where we are right now. So that's kind of my take on the individual side of it.
Well, let's get into some of the types of claims, and you anticipated the types you're seeing. The one in the news all the time is the long haulers, and we're getting new information on those types of individuals daily. Glenn, what kind of legal and factual issues are you anticipating?
Well, I think, sorry, Artie.
Yeah, go ahead.
Well, I think first we should probably define long hauler. There's lots of folks who were getting COVID. It was being treated like the flu. It came, it went, everything went back to normal. However, there were people who got the virus and it stayed with them, in many cases for more than 30 days. And while they may have gone home from the hospital, they may have appeared to get better. Doctors are producing, or doctors are producing reports at a rapid rate about what they're seeing as long-term side effects of the people who are long haulers, not the folks who tested positive but were asymptomatic, but rather the folks who had a severe condition, those folks who ended up in the ICU, or maybe who were at home with it for 30 days. Some of the long-term effects, which are more innocuous than others, are lack of smell, lack of taste. And, I've been joking to my staff, unless somebody's a sommelier or a brewmaster, those aren't disabling conditions. But we're also hearing on people with severe lung problems, severe fatigue, and pulmonary issues, and not pulmonary, cardiac issues, and also cognitive issues. And those are the kind of things that will arguably prevent people from being able to perform the material duties of their occupation with regular continuity, which is the California definition of being disabled. And we anticipate it's going to be a whole new world of carriers having to look at these people and say, well, we've never seen a COVID disability claim, but we have to consider it.
Misty, what do you think? And Glenn, I'm going to get back to you and ask you what you think you're going to have to do to establish disability for these insurers. Misty, you want to get your comments on what Glenn was talking about in terms of the long haulers, the nature of the claims.
Yeah, when you talk about disability claims, there's a process, and it's a little more challenging when you have subjective complaints. So you have someone who has a diagnosis, then they have a medical condition. That medical condition has to cause restrictions and limitations, and those restrictions and limitations have to prevent that person from being able to perform the substantial and material duties of their occupation with reasonable continuity. And whether in California, whether you're in an individual or an ERISA context, that definition, the ERICA definition is followed. So in the context of some of these long hauler claims, and when you talk about objective versus subjective evidence of the condition, and then objective versus subjective evidence of the actual impairment, there have been a lot of discussion and articles that equate some of this fatigue and post-exertional fatigue that is seen in long haulers as being very similar to what we saw with chronic fatigue syndrome and complaints of pain. In the ERISA context, and even I think in the non-ERISA context, you can't just ignore subjective complaints, but they can require objective proof that those complaints disable you. Now, how that's going to play out in the context of long haulers, we believe it's unknown. It could be very similar to chronic fatigue and fibromyalgia. I mean, there are ways of objectively measuring impairments and how they affect you. So I think this is going to come down to the whole analysis of the subjective versus objective. And if there is objective evidence that is contrary to the subjective complaints, I know Glenn may disagree, but there's a sufficient amount of case law that says the insurance company, and particularly claims administrators, they can still rely on that to deny a claim. And we also have to look at the whole treating physician rule, particularly in the context of ERISA. ERISA administrators are not required to accept the statements of a treating physician. They aren't required to give it deference. They're required to do their required and able to do their own analysis as to whether there's sufficient objective proof of disability, which is a very different thing than just an objective proof of fatigue.
So one of the differences that strikes me in terms of COVID-19, say a fatigue situation from chronic fatigue, is that we know that fatigue is one of the potential side effects of COVID, and we can get objective evidence that the person had or has COVID, which we don't have for the chronic fatigue. We don't have the same kind of objective evidence of the chronic fatigue. How's that going to play is what I'm wondering, because you could say, well, you got objective evidence of the condition, but not necessarily objective evidence of the symptom.
But it could be similar to the fibromyalgia cases. For the longest time, nobody really knew what to do with those. But there is, according to the ACR, specific criteria and trigger points that you can look to make the diagnosis. But that doesn't mean people with fibromyalgia automatically get paid. The analysis is still going to be there. Yes, they had COVID. Yes, they have chronic fatigue. Yes, they have fibromyalgia. I think those are all diagnoses that are fairly well established in the medical community and in the disability context. But you still have to go through the next step. Are they producing restrictions and limitations and impairments that are to such a severity that the person can't work? And these are all going to be very, very fact-specific scenarios. And now where, people are working from home, that's something that's going to come into the mix, is how are they performing their job duties? And are they able to perform them in the usual and customary way?
So Glenn, my question for you is, how in terms of long haulers, how are you going to go about proving whether the insured is disabled or not disabled? And you brought up the example of if you're a sommelier and you lost your sense of smell or touch. I'm thinking, well, yeah, but there's also a lot of chefs out there that it could also that could affect theirs, and there's a question of how long these symptoms are ongoing, and how significant is the fact that they may or may have been in the hospital for weeks or longer, or may not have been on a respirator. What's your thinking on how to go about proving disability?
Well, like any disability case, somebody's in a fender bender at 5 miles an hour and they claim they're disabled, they're not walking into my office. Somebody's in a horrible car accident and they're laid up in a hospital for 3 months, completely different story. So I think it's going to be a factor as to how long somebody had COVID and how serious the condition. You know, I was being somewhat trying to give a light reference to the sommelier without being able to smell, and I really hadn't thought about chefs. But I think the bigger issue is going to be the probably thousands upon thousands of people with fatigue, pulmonary issues, cardiac issues, and cognitive issues. And I think this is the first time in 20 years I actually agree with Misty that these are going to be very factual cases. You're going to have to look at the person's occupation and decide, are there provable symptoms which prevent them from working? Now, we're going to disagree as to the subjective versus objective. The Ninth Circuit has said you can't ignore subjective symptoms, especially for those for which there is no proof. If a chef says, I can't taste or smell, and there's no way to test it, and that chef had a long-term case of COVID, I think the carrier is going to have to accept it, and if they don't, they'll lose in court. But as a plaintiff's attorney, I don't want to go to court with just subjective evidence, with the claimant telling me something that I can't prove. For the other things I've talked about, typically there are objective testing methodologies to establish deficits. If it's a cognitive deficit, if they have memory issues or focus issues, we can have a neuropsychology psychology battery done that should demonstrate that they have a deficit from their prior level of ability. Fatigue is going to be difficult, but there is a number of testing facilities performing what are called CPET testing, cardiopulmonary exertional testing, where an insured or claimant will go to them. They're put on a bike with all kinds of technical things attached to their body to test their ability to ride a bike for 10, 15 minutes. But then what's important is they come back the next day and do the same bike ride, and to see if their ability is the same or if it's decreased. If we have a positive CPET test showing that their fatigue is real, we think that's objective evidence. There are certainly pulmonary tests that will demonstrate that somebody has long-term lung damage. You know, if it's a lawyer who's mostly sedentary, that may not be disabling. If it's a construction worker who has to be in his feet all day doing heavy work, it could certainly be disabling. So, you know, agreeing with Misty, which I really hate to do, it's going to be a case-by-case factual question about the job duty and the provable limitations or restrictions.
Would you also agree with Misty on the fact that your job duties might be much different now that remote work is available to people than it was before COVID hit?
Oh,
it might be that. Yeah, go ahead, John.
I suspect it will be argued by the insurance company, but I've also heard for my entire career from insurance companies the ability to get to work. For example, if somebody has issues where they can't drive, is not the insurance company's problem. So theoretically, whatever somebody's doing from home working is the same thing they did once they got to the office. So, you know, if the position of the insurance company is, well, you're at home, go take a nap every couple hours. As an employer, I currently have 49 people working from home. The only one allowed in the office is me. And I expect the same level of work even though they're home. Probably delusional since those with kids, but that's a different issue for a different day. So I don't think the working at home is going to be a big factor.
So can I just add one thing? You know, getting back to the whole, you know, how the claimant is going to prove their case. You know, one of the things that insurers would often rely on in if there's evidence in the record or evidence that shows that these claims are just not credible, a lot of carriers and administrators rely on surveillance. They rely on social media to see if the individual is engaging in activities that are at odds with what they're claiming. And, you know, with these shutdowns and restrictions and, you know, us being a little more cautious and not running around and going out all the time, I think that that's something that is going to be a tool that insurers and claims administrators would use often. And that I think is going to be significantly impacted because people just aren't out doing the activities and things that they used to. They're staying at home. So
I was wondering about that, whether the investigative industry was going to get a big lift out of this. So you think there's going to be more surveillance rather than less?
No,
I think it's going to give less results.
Yeah, okay.
And
because people are stuck at home.
I can also imagine the litigation where there is surveillance where the person says, that's not me, because they're wearing a mask. And it's like, well, is it or isn't it? But they usually stop outside their home and film them as they leave. But I agree with you. That's an excellent point by Misty, that there's going to be less surveillance because there's less activity. And when companies engage, investigative companies, to perform surveillance, they want to do it surreptitiously. And as you've all seen with the roads, they're a lot quieter. It's a lot harder to blend in when you're the only one sitting in front of somebody's house because there's nobody else there. And social media, I think social media has expanded dramatically, but it's just people talking rather than talking about what they're doing. They're commenting upon, you know, how much more wine they're drinking at home or the presidential election. They're not getting out and doing things. I mean, you know, I've often had cases, you know, I hate these cases of chronic fatigue where the social media says, yeah, I just took a 5-mile hike up at Malibu Hills. And it's hard to argue that they're really fatigued if they're doing that. Right now, people are hopefully not engaging in those activities.
Yeah, well, what about the people that are immunocompromised, you know, and they might not be having symptoms, but they might be highly subjected to COVID or to serious consequences if they have COVID. How are you treating those? Miss, do you want to take a crack at that before Glenn does?
Sure. So this is what, you know, we all know are the risk of disability, risk of relapse cases. There's not a lot of case law out there. It's mostly in the ERISA context. But the general proposition is that if the insured can be considered disabled, if it's impossible for him or her to work without significantly risking their health or their life, the important part of that issue is that there has to be a significant risk. Just a slight risk is not going to be enough to render somebody disabled. And again, I think this is going to be something that's very fact specific. You know, for example, you're going to have to look at the workplace. You're going to have to look at the safety protocols that people can take. You know, for example, you know, I'm immunocompromised, but I can go to work because I can wear a mask. I have my own office. We stay socially distant. And it's not risky for me to go into the office if I have to. It might be completely different for someone who's a frontline worker. So I think these are going to be things that have to be examined, very fact specific, but, you know, with all the CDC guidelines that are out there, you know, essentially outlining safety protocols for people to continue on with their life. I think that it's not going to be so easy to say, well, I'm at high risk and therefore I can't go to work because I might get COVID. I did look just out of curiosity. There are a couple cases out there that talk about risk of infection and someone who has immunosuppression. And the courts kind of entertain the idea that that might be a disability. But there was just not sufficient evidence for that to actually get to the point where the claimant was able to prove that going to work with their condition was a significant health risk, risk to their life and their health. So I think these are going to be very, very fact specific with the CDC guidelines. I by no means do I think this is going to be a slam dunk just to say I'm at high risk and therefore I can't work.
What about somebody who, for example, has to get there on public transportation? Public transportation is really, there's no way to social distance on the bus or something like that on BART. Whether people are told that they have to social or not, it's pretty hard to police.
Well, I think
Let's say I'm just going to make up a hypothetical. Let's assume, I'm going to throw you a curveball here. Let's assume someone is 60, undergoing, has had cancer treatment last year. If they get it, it's very high risk of death, but they have to go to work on the bus.
Well, Glenn mentioned this, is that there is case law that says your ability to transport and get to work, that's not considered disabling. So I don't think the public transportation is going to be a deciding factor. I mean, the reality is people are flying, people are taking buses, people are taking Ubers. I mean, people are getting around even if they can't drive. Transportation is going to be a deciding factor, at least not under the case law as it stands right now.
Glenn, what do you think on this subject?
I fully agree with Misty on that. If your scenario walked into my office, or actually called, since nobody's walking in right now, I would probably decline that case as a contingency lawyer. I would say, look, your employer needs to accommodate you if possible, or you need to do other things. But the requirement that you take public transportation, it really doesn't exist, because people can Uber, they can drive themselves. That's just not a disability. From my perspective, and I actually have some of these cases already, it's like an XY curve or XY computation.
Right.
What's the occupation and how severe is the risk to the insured? I'll give you a couple examples of cases I have. I have an ER doctor. Her specialty is ER. Her private disability policy is that of an ER physician, and she has asthma. The insurance company said, when we were convinced you had severe asthma, we decided to pay you. Your asthma is now under better control, so we've decided the risk to you is not what it was, so we're going to stop paying you. So in that case, they're saying, yes, if the risk is bad enough, we'll pay, but there's a factual dispute about how risky it is to you. I agree with Misty once again. Cases like that, they're factually intensive. A trier of fact will have to decide who's reasonable. Frontline workers, I believe, are going to have strong cases. I have a young man with a very, very serious illness, makes him extremely immunocompromised. He goes to work, he did go to work every day as a machine worker. And his doctor told him, if you get COVID, it's a death sentence. And he decided to stay home. There was no way to accommodate him. And the carrier denied him, saying, well, we just don't think that's a disability. We're in court now, and we'll see how it comes out. But these are going to be very factually intensive cases. I would think most carriers will lean into paying these kind of claims if the facts are strong enough. I think they realize that in the world we're in right now, a trier of fact is going to be sympathetic to an insured in that situation. And
when you say the fact,
go ahead.
Go ahead, go ahead.
No, go ahead.
When you say the facts are strong enough, are you talking about the degree of risk depending on what their immunocompromised condition is? In other words, how serious a risk it is? Because some people can be compromised, and some people can be at much greater risk depending on their condition. You're saying there's sort of a sliding scale there?
Yeah, I think there is. I think if somebody had cancer 5 years ago and they say, well, if I get it, I'm going to be more susceptible, I don't know how sympathetic that is. If somebody has a current condition where they're immunocompromised and their doctor tells them that COVID could be extremely dangerous for you right now because of your current condition. I'm trying to think of an example. Somebody with a somewhat severe case of MS, that could be a good example. Somebody with a bad back to say, hey, if I get if I get COVID and I end up in the hospital, I could die. Well, the bad back is not going to make them more susceptible to COVID than anybody else in the population.
Misty, what do you think? Any comments on what Glenn said?
No, again, I trying a couple of I think one of those cases is actually with my office, so I have to be careful. But I mean, I suppose there's a situation where somebody who can't work from home, who has severe immunosuppressed condition, and maybe they have a condition where they can't wear a mask. I mean, I guess those kinds of things could exist. But I think as a general proposition, that the risk of disability cases, it's going to have to be someone who's an essential worker in a high-risk situation and not able to take sufficient safety protocols to protect them from significantly endangering their health.
And from the 30,000-foot level, on the ERISA claims, I think you're going to find the short-term claims will get paid, because for the most part, they're being paid either after state disability in a state that has state disability, or they're being paid with the employer's funds. And I think all practitioners, from the plaintiff's point of view, see insurance companies much more willing to approve claims where they're not the actual payee. And if there's a 6-month elimination period before we get to long-term, it's a pretty lengthy time. And I think the carriers are going to be hoping that that vaccine comes through or the curve goes down. Haven't seen it yet.
We all hope that.
We all hope that. We all do.
Not just the carriers.
I thought we had a cure. I don't know. I read that someplace too. We had a cure. Okay, well, let's talk about, is this going to create more PTSD claims? And are we going to see that as a physical condition or a mental condition? Glenn, what do you think?
Well, don't hold this against me down the road, Misty, but I would have to say, if it exists, it's a mental condition.
Yeah.
I think PTSD is absolutely a mental condition. There's going to be probably a 2-year limitation in all claims. I don't think there's going to be a huge amount of it, but there will be some. And I'm not talking about people who had COVID and are claiming PTSD. I'm really talking more about the frontline worker. I mean, we've seen stories about doctors committing suicide because they couldn't handle what was going on. And if a doctor spends a year treating people and has hundreds die, and they leave the practice of medicine for a while and make a claim, I think that's a hard claim to deny. But I've seen it. I haven't seen it happen, but it's a case I would take on and fight.
Misty, what are your thoughts?
Well, I agree with Glenn. These are pretty well established that these are mental nervous conditions because there's a DSM diagnosis for them. And most plans define mental and nervous disorders as those to include DSM diagnoses. With the PTSD, though, while a lot of it is subjective reporting, there are very, very specific factors that are set forth in the DSM. They have to prove exposure to a stressor. They have to prove certain symptoms that exist, and the symptoms have to exist for a certain period of time. So although it arguably is based upon some subjective reporting, there are specific guidelines and criteria that the DSM sets forth in order to establish that diagnosis. For the most part, though, I mean, they are going to be 24 months, but also you know, PTSD, it is not considered a lifelong condition. Well, let's hope not. But, you know, most, and Glenn can certainly disagree with me, but, you know, most post-traumatic stress disorders they're not lifelong. They're going to be treatable and hopefully short-lived. But I could see them in the context of these frontline workers, particularly the beginning, as, you know, people were having to make decisions to who gets treatment and who does not.
And for the most part, I agree with everything Misty said. And going back to my prior statement, if people have to start with a short-term claim and it's 6 months long, hopefully that would allow them to be treated and recover. Another issue, given the present curve with 100,000 cases being reported a day, they may say, I can't go back to doing that. It's too stressful. That's going to be a whole different kind of claim. But the carriers, in their wisdom, limit these claims to 2 years. So they may not want to fight them as vigorously as they would a claim that has a 10, 15-year potential. So we will have to see down the road about those kind of claims. I have not seen one yet in my office.
So next question I wanted to ask is, what about people that are furloughed because of COVID? How is that going to affect the claims process? Glenn, you want to take a crack at that?
I'm happy to talk about it. I have no answers other than it's given me nightmares. We've had over the years many cases where somebody goes out on disability or goes out for family leave of some kind, thinks they still have coverage, and in fact, the employer might even be paying premiums to the carrier. And while they're out, either on disability or family leave, something happens and either they have a disability or they die. The claim comes into the carrier that says, oh yeah, we were getting premiums, but we have an actively at work requirement in our policy. So you didn't meet the terms, your coverage stopped, and we're not paying this claim. Some policies, and you know, this is very policy specific, allow an employer a certain amount of time to keep somebody on a policy while they're away from work. Typically FMLA periods, some if they're ill for up to a year, others don't. And the employers very rarely really know what their policies say, and employers can be dangerously generous in saying, we're going to keep paying your premiums, or we'll let you keep paying the premiums. And the situation where premiums are paid, but the insured is technically under the policy terms not eligible for continued coverage is going to present just all kinds of problems. And people don't know it. The employers don't know it. And my suspicion is the insurance companies aren't paying attention to it.
Misty, what do you think? By the way, I just wanted to mention to the audience, if you have any questions, we might have a few minutes at the end. Just send them in on the chat. We'll try and get them. Yeah, Misty, what do you think?
Well, there's two things in the context of the group coverage. Glenn is right. They must always contain an active at work requirement, and they're going to be very specific as far as what is considered actively at work. What happens is oftentimes, and we see it all the time, whether it's a disability or a life or conversion, when they stop being active at work, either because they've been furloughed or they themselves, if they've gone out on disability, we get into all kinds of issues of, you know, waiver of premiums and continuation of coverage. But just looking at the furloughed employee, if they are no longer actively at work, then they don't qualify. If you have an employer, and we do see it a lot, where the employers keep paying, then you have the issue of, was there a waiver of that active at work requirement? Was there an intentional relinquishment of that right to enforce that provision? In the context of the insurer, they are not administering these plans. A lot of times they're just getting bulk premiums. Most often what we're seeing when they're able to prove a waiver, which in ERISA, it's a higher burden, but it's oftentimes it's going to be the employer who's the one who screws up and who continues paying the premium knowing this person is not eligible. So I don't think it's not as often the case where the insurer that's funding the benefits is found to have waived it, because they're usually just getting a bulk premium, and they don't administer, they don't know who's working, who's not working. That falls on the plan administrator. And but I do want to touch a little bit about what happens in the individual context, because we do have situations where, you know, what happens when a person who has an individual policy and they become furloughed and they're unemployed. What's their occupation? Are they unemployed? Or are they retired? You know, you're going to have to look at the individual policy language as well. Does the policy provide coverage for someone who's retired? Does the policy define someone's regular occupation is the last occupation that they were performing when they were gainfully employed? So you could see those issues coming up in the individual context as well. And you're going to have to look out, you know, did the person intentionally abandon their job? Did they leave their job, or were they involuntarily laid off because of COVID? So it could come up in the individual context as well, not just in the group context.
So as I understand it, then let's just again take an example. If the government shuts down a business and all its employees are furloughed, does the company has to continue paying the premiums for everybody in order to keep that policy in place, I assume? And if you got to be at work for 90 days and the government says, okay, you can open up on the 91st day or the 120th day and everybody comes back, but somebody got disabled in the meantime, they could have no coverage then. Is that the issue? Even though essentially they were ordered out of work by the government.
That's the issue. But the ultimate answer will depend on a lot of things. And we go back to the policy. As I said, many policies allow the employer to continue paying premiums for a worker for a certain period of time. Others don't. If they don't, if the policy says no, you have to be actively at work, but the employer continued to pay premiums. I agree with Misty that there's an issue, but here in the Ninth Circuit, it's not such a clear-cut dichotomy as to who bears the responsibility for what. From our perspective, it's the insurers who set up the methodology of accepting premiums. And if they want to put it on the employer, we would argue that they are letting the employer handle this, and they bear the burden, or at least some of the burden. And typically, when we get into litigation on these issues, where there's a dispute between the employer and the insurance company, we're thrilled when they just point the fingers like this, because from our perspective, money is fungible, and we don't care who's paying the benefits as long as one of them do. I mean, this situation has come up many, many times over the years in the life insurance context, where somebody leaves work due to a disability, they don't have what's called a waiver of premium, and the employer or the insurance company neglects to give them their conversion rights. And in the Ninth Circuit, there's strong argument that as long as premiums are paid, or even if they're not paid, if there's no conversion right and the insured dies, they have a right to get paid. And we think the same thing is going to happen with COVID.
So we got a couple of questions here, one related to this topic. Should the fact that a person is terminated by their employer after they've submitted their disability claim, presumably after FMLA has expired, affect their eligibility for LTD benefits? Either of you want to answer that?
Well, I need more facts, but were they still covered when the disability started? I mean, are they off of work because of they personally had COVID? Because if that's the case, as long as they have coverage, the fact that they're terminated while disabled is irrelevant to their disability claim. The question is going to be, what if they're terminated while furloughed and a month later they get COVID and become disabled and can't return to work anywhere? That's going to be a subject of litigation as to whether or not they remain covered.
So we were actually, our last question was here going to be related to pre-existing conditions. But we have a question from the great lawyer in New Jersey, I believe. Pre-existing provisions being used for someone with general medical treatment in the 3 months before policy coverage and then later diagnosed with COVID. Misty, you want to handle that one?
Yeah, you're going to have to look at the policy provisions. I mean, you know, in the group context, there's usually a 12-month look-back period, and they're often drafted quite broadly. Did the person have any consultation or treatment for the condition? Diagnosis is not always required. But again, I think that's going to be very policy specific as to how that pre-existing condition limitation is drafted. If it requires diagnosis. Yeah, if it requires diagnosis or just treatment of symptoms. They're two different things, and I've seen it both ways.
I agree. I think Misty may have misspoken about the look-back period. The look-back period is not typically 12 months, it's 3 months. It's the 12 months is going forward, where you have to work for 12 months while insured in order for pre-existing condition exclusion not to be applied. So with COVID, I think there's going to be 2 different scenarios. One, the person is furloughed, is off for some period of time, and goes back to work for the same employer under the same plan with the same insurance company, and has COVID while they're off and comes back to work and has long-term effects. Insurance company may say, your coverage stopped, therefore this is now new coverage for you, and this is pre-existing. The issue there is going to be, did their coverage really stop? That's going to be an interesting fight in litigation. The other scenario is somebody is off of work, gets COVID, has long-term effects, and goes to a new employer and works for, let's call it 4 months, and they just can't continue working because of cognitive fatigue, whatever. And the employer says, not the employer, the insurance company for the employer says, this is pre-existing, we're not paying. Once again, while there's a fight about no pre-existing in healthcare, nobody's ever argued that disability carriers can't impose pre-existing conditions. And it's not a case I would take on. If it's with a new carrier and a new employer.
Misty, anything you want to mention about that before we wrap up?
No, I mean, I have seen look-back periods that are longer than 3 months, so I think it depends on what the policy says. The group tend to have longer ones, but no, I don't have anything else to add. And I know we're about out of time, and Nevada's going to announce its results soon. So.
Yeah. All right. So, well, we'll wrap it up then. Thank you very much, Glenn and Misty. Your thoughts are really deeply appreciated. You're obviously at the top of your profession here, and I'm going to turn it back to Natalie and Jeff.
Arnie, Misty, Glenn, thank you all so much for a program that was just chock full of information and really highlighted your expertise, and it's very helpful to everybody who was listening. We appreciate your support of food banks, the San Francisco Marin Food Bank, the food bank in Los Angeles, San Fernando Valley that people mentioned, or the food bank of your choice. If you're comfortable, those who are able to make contributions, if you're comfortable informing Natalie of those contributions, we're happy to add them to our running total, and we hope that we'll break $60,000 by the time we see you next week. Natalie, any final words?
Jeff, I just want to say thank you once again to Arnie, Misty, and Glenn. The presentation was fantastic. I know everybody wants to get off the Zoom call so we can check our presidential election updates. So thank you all so much. bonne route.
Okay, thank you all. We are
Thank
All
complete.
right.
Bye.
Thank
Bye-bye.
you.